is the Chief Magistrate Agbara Magistrate Court, Idioke Magistrate Court. So please, you will take note of that and listen carefully. You are welcome, sir. It's covering everywhere from all our boundaries. Itoyin, Idioke, Agbara, Ibesa.
Good afternoon, everybody. Good afternoon. I'm so glad to be in the midst of these pleasant people. Yes, permit me to stand on the protocol already established by the area commander. Yes, as Omo Yoruba, I have to especially greet my elders in the house, the Kabiyesi, the representatives of our royal fathers. Thank you very much. Good afternoon, sir. And the service chiefs too. I want to especially say good afternoon to you. Sorry that I came late to the program. I had to really attend to some pressing cases in my court in order not to look as if I didn't do anything for the day. I'm sorry for the lateness, but I thank God that at least I'm not that late. Yes, I'm still ahead of time as per the delivery of my topic today. Yes, while I discuss my topic, I will make it more interactive as much as I can. I'm not going to sound too technical, so at least I have to come to the level of everybody in the house. Yes, I start with that it's a privilege to address this distinguished gathering of stakeholders at this important meeting convened by the Nigeria Police. I commend the initiative behind this engagement. Conversations of this nature, like I said, are not mere formalities. They are essential if we are serious about strengthening our criminal justice system and by extension, the security of our society. I like to say that there is nothing judiciary can do without the help of the Nigerian police. Like area commander, like we said earlier, we have a symbiotic relationship. We must synergize. There must be a synergy between the judiciary and the police in order to strengthen the security architecture of the state. My intervention today is on the administration of criminal justice with a focus on the roles of judiciary. Let me begin with a simple but fundamental question. That is, what is the true measure of an effective criminal justice system? And I go ahead to say, is it the number of arrests made by the police? Is it the speed with which suspects are charged to court? Or is it the number of convictions secured? I think everybody listening to that. What would be the answer out of the three things that I mentioned? But I was surprised to say that none of that is the answer. The true measure is this, that is whether justice is delivered fairly, promptly, and in a manner that inspires public confidence. That is the standard we must hold ourselves to. So when we talk about justice, we are talking about prompt dispensation of justice, and we are talking about fairness in the justice delivery. Again, Bashimanso, the court is the last hope of common men. Yes, when you come to court, you want justice. You don't want your cases to be compromised. And that is why the public, the society, has a trust in court. The administration of criminal justice is a chain of responsibility. The police investigates, the prosecution evaluates and presents the case, the defense tests the evidence before the court. The court representing the judiciary stand at the center as impartial arbiters. And at the end of that process, society expects a result that is just, credible, and lawful. But let us be frank with ourselves, where one part of this chain is weak, the entire system suffers. And that informed what I earlier said, that we cannot work without the assistance of the police. We depend on each other as institutions. So the judiciary in this framework plays a role that is both decisive and corrective. The judiciary is the guardian of due process. Every arrest, every detention, every piece of evidence must pass the test of legality. This is not a technical burden placed on law enforcement. It is the very essence of rule of law. If the process is flawed, the outcome cannot stand. Yes, is it possible for somebody who has not committed any crime now to be arrested while the person is just going on the road? Do you get it? Yes, at times let us say the reality. We know how many our ọlọ́pàá. Yes, thanks to that number they have brought some people. I'll have to question the IPO at times. Why were these people arrested? Maybe probably we have numerous suspects before us. And it will appear as if that person or those people, they will be working at night, at times when police need to perform their raiding. We'll see. He got in by now, so got in election. Olódodo máa ń fara bá bẹ̀. But that is why the court is there to discern between the truth as to what actually has transpired. So we have had that in numerous cases. And thank God, the court in its wisdom, kò ń ṣe agbára wa náà, òye Ọlọ́run la fi ń gbé gbogbo everything. Because there is one thing about justice which you must know. It is better. I remember the first time I met with my sister, the area commander, in her office. I told her something. We have to be very, very ready as judiciary. When we have 100 suspects before you, it is better to allow 99 of those suspects truly they have committed those offenses alleged against them. It is better to allow them go than punish one person who is innocent. And that is why the court is very, very wary and careful in passing judgment. You have to be, there's standard of proof in a criminal prosecution. I'm sure everybody must have heard and known that. In criminal prosecution, they will tell you that for a defendant to be convicted, it means that the prosecution must do what? Prove its case beyond reasonable doubt. Beyond reasonable doubt does not mean any iota of doubt. Àmàrí àwọn àpẹẹrẹ ọ̀dà máa gbò pé but beyond reasonable doubt means that a gbọ́dọ̀ rí ẹ̀rí àrídájú lẹ́nu iṣẹ́ ká tó fi ilẹ̀. And I will still go ahead in the course of my topic while the society who brought or who arraigned the defenders at times, just like the area commander said now, that when you see somebody you brought to court, you suddenly saw the person outside, you feel cheated as if what is happening. Any ìlànà aspect lánàá nílé kó ti tú jáde, there are constitutional safeguards to that effect. It doesn't work that way. The way it appears to society at large is not what the law is. The law presumes somebody, a suspect, to be innocent until contrary is proved. So at that point of arraigning that person in court, the court does not have the right to adjudge the person as being guilty. So what the law enjoins the court to do is to admit that person to bail at that point. And ìdí pàtàkì tẹ́ máa fi ní wọn yẹn bá ní wá sí kóòtù lẹ́yìn kóòtù àfihàn ní bail. Granting the defendant's bail does not mean acquittal. It does not mean that the person has been discharged and acquitted of the charge. We only get temporary freedom that we are not yet sure. It has not yet been established that you are guilty of the allegations made against you. So we allow that person to go while he faces his trial. So let me continue. There must be full implementation of the Administration of Criminal Justice framework. Its provision on day-to-day trial, electronic recording of statements, and non-custodial sentence are critical tools, not optional. There must be investments in technology and infrastructure, efficient record keeping, digital processes, and where necessary, virtual proceedings will significantly reduce delays. I think we are transitioning to this level now. Now, the state judiciary has been able to move into the digital judiciary, where we do virtual court proceedings now. It might be in America, it might be in anywhere, and you'll be able to have your trial without being able to appear in court physically. Very importantly, there must be an accountability across all levels. A system that does not account cannot command public trust. Let me emphasize this point. The judiciary cannot succeed in isolation, just like I earlier said. Its effectiveness depends largely on what comes before it. If investigations are weak, prosecution will fail. If prosecutions are careless, trials will be prolonged. And if trials are prolonged, justice will be what? Undermined. Therefore, synergy is not a choice, it is a necessity between the police and the judiciary. So, just like I have said, like I always tell my the prosecutors in court, you have to be diligent with the handling of your cases, because any slight error will lead to the discharge and acquittal of a defendant. So what we are saying in essence is that investigation is the pillar of every prosecution. It starts prosecution, effective prosecution, or successful trial starts from investigation. So I want to enjoy the IPOs in court when you are saddled with the responsibility of investigations. It is not for you to just say, I obtained the statement of the defendant or the defendant confessed. It goes beyond that. You have to do the due diligence. It's not about you are saying that I visited the scene of crime. At the scene of crime, what did you discover at the scene of crime? Do you get it? So a prosecutor is enjoined to do its work diligently. And like I have said in my paper, that it plays a crucial role in ensuring timeliness in the administration of justice. Delay is one of the greatest threats to the credibility of our system. A case that drags on endlessly does injustice to the victim, the defendant, and the society at large. At this point, what use is justice that comes too late? The answer is obvious. It loses its value. That is why courts must continue to adopt strict case management practices, minimize avoidable adjournments, and ensure that trials proceed within reasonable time. The principle is clear. Justice must not only be done, it must be done without undue delay. Although the judiciary is central to sentencing and correctional justice, sentencing is not merely about punishment, it is about purpose. It must deter, it must correct, and in appropriate cases must rehabilitate. Yes, like this now, if a person is found guilty, might wonder at times that this person is found guilty, why is he allowed to come out or go to the public, and what is he doing outside again? Kò sí ìgbà gbogbo ni tàbá sọ pé èèyàn jẹ̀bi ló máa ń lọ sínú ọgbà ẹ̀wọ̀n. Yes, what we call non-custodial sentences. These are alternatives to ọgbà ẹ̀wọ̀n. Rather than sọ pé a fẹ́ tún yàn lọ sọ́gbà ẹ̀wọ̀n, at times I must say, okay, what can you do? Considering the magnitude of the offenses committed by that person. You might just think that, okay, this person has stolen a 10,000 naira chicken. So what do we do in circumstance to punish it? Should we say because of the 10,000 naira chicken, we are going to send in, because punishment for the offense of stealing is 7 years imprisonment term. At 10,000 naira, see of them to get 10,000 naira. So what the court has said, what the ACJL, the Administration of Criminal Justice Law, part of the innovations introduced by the ACJL, is that when you go back here at the 10,000 naira, òfin kì gbà wọ́n láyè pé okay, let the person undergo a community service. A lè gbé lọ sí school, a lè gbé lọ sórí ìta mẹ́ta ìdí ọ̀gẹ̀, ọ̀gbẹ́ni yìí lọ́dọ̀ wọn máa dá lára rọ̀. Do you get it? So it's not about sending somebody to and spend the whole time in jail. And there's something we call restitution. Because administration of criminal justice too is all about corrective justice, restorative justice. Restorative justice is that they stole your bike, and they sold that bike. A bike worth 1.6 million naira. Now, the court finds that person guilty. So what do you think should be the justice? If I am to go by my judicial sword, I will say, okay, you have stolen and I have found you guilty, let me sentence you to